name is Jennifer Young. I work for Laughlin Associates. I'm a senior corporate executive. Have many titles, but that. And so if you're not familiar with who we are and what we do, we have had a presence in this community for 50 years. So we do entity formations, LLCs, corporations, nonprofits. But really our focus is asset protection. So we do elaborate strategies, but at the simplest form, asset protection, when you're investing, usually you should try to have like an LLC or something to separate you from what you're investing. So personal liability separate from investing, right? So that's just kind of like a generalization of what we do, because we do a lot of different things. But I'm going to kind of talk about lawsuit protection, because obviously anybody who is investing is super rich, right? Or anybody who has a business, that's what people think, right? And so the more you have, or the more perception, I guess, that people think that you have things, they want to come after you. So kind of want to go over that a little bit. So I'm not an attorney. I'm not giving you legal advice. If you need legal advice, or if you found yourself in something, let me know. I can give you a referral. But that's our disclaimer that I am not a licensed attorney. So really what our mission is to help entrepreneurs protect their assets and help them accumulate wealth, but doing it in a compliant way to where they can stay wealthy, continue to build their wealth and be stable. So as I said, we do corporations, LLCs, nonprofit formations, lawsuit protection planning. Those are our asset protection strategies. They can be in a very simple form and then kind of morph with you, or they can be very elaborate. We do estate planning, corporate compliance services. That's really just helping you with your compliance of your business. And then we help with trademarks. So there's lots of things you can do with investing. You don't want to go into it blindly. The worst thing that you can do is just to start buying things and not knowing the ramifications of properly protecting what you have. So obviously, like we discussed, you're kind of a target for people. They think that you're investing, they think you have all this money. So everybody thinks that you're this person. So what we really want to do is reduce the incentive for people to come after you and for you to be a target. So most investors, seasoned investors, will use LLCs to kind of provide a shield while they're investing. So again, that separation from your personal liabilities and your assets, and then, you know, back and forth. So you're protecting the business from yourself, you're protecting yourself from the business. So there's lots of reasons to have an LLC. So obviously the asset protection is usually the number one. There can be tax savings depending on where you live, what kind of revenue you have. If you're doing itemizations, you can do it at a much higher rate when you have a corporation or an LLC than as an individual. Protect against creditors, of course, estate planning, prestige and credibility. Obviously, when you have an LLC or a corporation, people think you're more reputable rather than you just as a person investing. And then partner protection. So obviously there's agreements. You can do like a buy-sell agreement or a customized operating agreement, or simply just a resolution to kind of lay out what that relationship is. So, ooh, I keep hitting something. So, an LLC, so really it's the liability, you're only risking your investment, right? So whatever assets you have under the LLC, that's really the only risk as long as you're compliant. It's controlled by the members. So you can either have it structured as member managed or manager managed. Taxes, you have the option to be taxed at the corporate rate or the individual. So An LLC is typically, you're taxed as a disregarded entity. So you're just filing one extra form, usually at tax time, saying either you made money or no, you didn't. Then as you start becoming more profitable, there's other options, like you could choose to be taxed as either a C Corp or an S Corp. It would not change the structure of your LLC, but you can have higher itemizations to be taxed as a corporation. And then exit, you'll have to get approval from all the members before selling interest. That's to protect yourself. So LLCs usually, when you're purchasing tangible assets, are the best way to go. Some people like corporations for different reasons. It's kind of up for debate depending on a lot of different things. But I say normally an LLC is the best way to go. Just because your tax liability usually will be lower and you can move assets in or out without it being a taxable event, which is helpful if you're buying and selling properties or flipping. You also will get charging order protection. So Nevada is a great state for incorporating and for investing. A reason is because we have a business court. Not a lot of the other states do. We also have a higher level of asset protection because it's in our statutes. Every state now has some level of charging order protection. If you guys don't know what that means, charging order protection is like when you have a company, and as long as you're compliant, like you can prove that you're a legitimate company, and let's say you were to get sued, the judge could essentially view or look at your company, and as long as you have all your compliance documentation, he'll go through everything, and the charging order is determined based on like all your minutes and your resolutions. So it's like the outlines and the decision making of the company, and he has to take all of those things into consideration before a ruling can be made. Well, that's really important because that's really where you're getting your asset protection, because that's outlining, let's say, the activities you're in. Maybe you're purchasing properties, maybe you're employing different people to help you, maybe there's repairs and maintenance, maybe you've entered into a lease agreement to where you're paying out funds. All of those things have to be taken into consideration before a ruling can be made. And so there's like 25 years of documented case law that the judge, like the criteria has to be followed before a ruling can be made. So that's really important, is to have that charging order protection, and every state now has charging order protection. So no matter what state you're incorporated in, it's helpful to have that, because if you don't have the compliance up to date, then essentially you have a company and it's not compliant, so there is no charging order protection. So that's really key to having a company. And so obviously having a company, if you have an LLC, you should always have an operating agreement. That's a key component of your compliance documentation that outlines the rights and responsibilities of each member. Also can help you manage the property and protect each member of the LLC in case of a legal action. So the liabilities go both ways. So if you are in an accident, I don't know, you stop suddenly and you tap somebody in front of you, right? Maybe they yielded because a bird landed in the street, right? And they didn't want to hit the bird. So you slam on your brakes and you tap them. Well, most of us have insurance that will either cover it or not, right? Outside of the insurance, though, sometimes people get greedy and they will come after you for like very small things. Sometimes it could be something serious, so the insurance will only pay out to a certain amount, or they might deny the claim altogether and you could be attacked personally. In the event that something like that happens, you want to make sure that if you have a lot of assets, number one, you should have them not under your personal name. You should always have them in an LLC or a corporation. People have this misconception that trusts will protect you, but if it's just a family living trust, all it really does is avoid probate. So the whole intention is to, you know, follow through the wishes that you had, and you have beneficiaries, then they can avoid probate. That's the purpose of a trust. But if you have your assets spread out in LLCs, and as long as your companies are compliant, then let's say somebody were to sue you, you had a personal suit, those assets could not even be looked at in court because they've had the protections of the LLC. Or vice versa, like if a company is ever sued, as long as it's compliant, they can't look at you personally, your personal assets, money you have in the bank, they can't look at the other companies. So hence that term corporate veil, because it's like this barrier. So again, they go both ways. So if you have your current assets and investment property, the whole point is to separate those out so they don't affect each other. So insulate and shield. So again, typically when people come to me and they want to have a strategy built, when we start talking about insulation and structuring, usually we'll talk about like values of the assets. So sometimes people, when they're investing in real estate, there might be several forms of investing, right? Sometimes people are purchasing properties to, you know, just hurry up and pick them up and fix them and then flip them, put them back in the market and sell. That's one investment activity. Another one would be, you know, you're purchasing notes. Maybe you're purchasing all over the United States. Maybe it's not demographically in just one area. But as long as it's not like the physical property and you're just holding the paper, it could even be like a syndication where a bunch of people are investing into that note. That's another category, right? Another one might be where you're generating passive income. So you're purchasing the property and then your purpose is to rent it out. So those are like three different types of investing that I usually like to separate out. You don't usually want those activities to flow through the same company or to be held together because one can implicate the other. And so when people ask me, well, Jennifer, I have 40 properties, like I'm supposed to have how many LLCs, right? It's not really one size fits all. Like some people, if you ask them, they'll tell you, put one property under one LLC. I mean, that's not really cost effective because there's so much that you have to do when you form a company, right? There's the compliance, there's taxes, there's all these maintenance fees. But if you're looking at the value of the home and the equity, like let's say you purchased, you know, an $8 million home and you've got $3 million in equity, well, that's a big investment. You would want that obviously by itself, right? But if you had like 3 properties that were under 100 grand and you only had like 30,000 equity in each, it would be acceptable maybe to put like 3 or 4 under one LLC, as long as they're in the same state. You can do that. So, you know, not one size fits all approach, but there's definitely different strategies you can do to make sure that you're properly protected. So you always want to evaluate the type of investing and then the value of the assets. So, you know, when you're talking about insulating and shielding, you know, maybe you have like different investments. You might have 3 categories and you may have like a holding company to kind of shield you. I mean, there's lots of different things that you can do. And if you're interested, I'll leave a stack of my cards. So I'll give you a complimentary consultation.
So you're saying you should segregate your LLCs by price point, or?
Yeah, so function, right? So like for instance, you would not want to have an operating company commingling what it's doing with a holding company. Like it's either going to be an operating company or it's going to be a holding company. The holding company typically will either own other companies or it'll hold assets, right? An operating company would be like, you know, you're providing services. Maybe one of your companies is a management company, like collecting rents from your properties, and maybe the other company holds the assets, maybe like the physical properties. And so you could be the owner of both. You could even have another company that owns both of those companies. There's so many things you can do. But yes, essentially by functionality and by value. Does that make sense?
What if it's the same function but a different price point?
Well, so like, give me an example of what
Our
you're.
residents.
Okay, so like, demographically, you wanna kind of pick where you're investing and try to focus, because like, let's say you have 3 different residential properties that you have purchased, and let's say you're taking loans out on all 3. You would wanna try to do it kind of demographically in the same area, because depending on how much the value, like, again, if it's like 200,000 and you have low equity because you took out a loan, let's say you have 20,000 or whatever down, let's just say, then you could put multiple homes under that LLC if they're all in the same state. Now, you can't really get away with having like a Nevada company, and a lot of people think, oh, incorporate Nevada and Wyoming, and then you can buy properties everywhere. It's true in a sense. If you have other LLCs, you also, there's other components, like you have to have residency or nexus. So there's lots of things that come into play, but typically, demographically, you want to try to have like multiple homes, if that's what you're investing in, under the same state. So like if you're investing in Ohio, 3 properties could go under an Ohio LLC, and you would want the LLC to be in the state that you're investing. If you're buying physical property. Now, if you're doing like syndications or notes and things like that, as long as it's just the paper, then you can pretty much incorporate anywhere. And I usually tell people wherever they're a resident of, or wherever you're paying W-2 wages, like if you're an employee somewhere, like Nevada would be a good state. Okay, so what happens to you during a frivolous lawsuit? Well, obviously we know, I mean, stress, you're gonna pay lots of money defending yourself, all these things, right? There's really not much you can do to shield yourself from frivolous lawsuits. However, I try to tell people, kind of be smart about what you're doing. So like, I usually tell people to structure their companies as manager managed rather than member managed. And the reason is because when people do like a public search, or they go to the Secretary of State and they look up your company, if it's structured as member managed, the term member is owner. So that word is interchangeable. So when people go look for free information, especially attorneys, like they'll have their legal assistant go find as much dirt on Facebook, Instagram, a Google search, or like the Secretary of State to see what free information they can find. If it's structured as member managed, it's gonna say managing member and then the owner's name. So if you had like 10 LLCs and they all have the member name and they're all you just gave a bunch of free information away, and then now you look more like a target. So I try to tell people structure as manager managed, because then anyone can be a manager. It can be a third party, like appointed position. It can be you as the owner, but people don't, there's no way for them to know that you're the owner. Or it could be a paid position, and you can change that position as much as you like. That's one way, like without doing extra things like putting an asset protection trust or layering and having other companies own that company. There's other things you can do, hire a nominee service, right? But it's a free way of just the way you structure your company. Now, certain lenders may require your company to be member managed. Like let's say you're getting a line of credit or a HELOC or something. Sometimes certain banks require your company to be member managed. So those are questions you'll want to ask your lender. I'm sorry, you had a question.
Yeah, I only looked into doing an LLC once, and are you able to be a member managed LLC if you only are the sole member of that LLC?
Sure, absolutely. Yeah, there's a lot of misinformation out there about structuring and about like the rules and about compliance. I have people tell me all the time, oh, I had one guy tell me, he's like, I have 26 LLCs. And I only do compliance on one because it's a corporation. I'm like, yikes, like, what year are they formed? Like, I'm asking all these questions because now I'm worried about not only his tax liability, just his liability, period. And come to find out he wasn't doing compliance on any of the LLCs at all because he didn't think he had to. And matter of fact, like 9 of them were already going to the point where like he wasn't doing the maintenance even for the state, which is like the very minimum. And so a lot of people think, oh, it's just me, I'm a single member, or they'll confuse the term sole proprietor. They're like, oh, I'm just a single member or sole proprietor. There is no compliance, and that's not true. It does vary from state to state, like what states require, but at the federal level, it's all the same.
So if you were the manager member or manager managed company and they could look at the owners and see just you, are you still kind of on the hook there?
Well, so like,
Or are they,
so I think what you're asking, so if it's structured as member management showing manager
no, if
my
it's
gosh.
structured.
If it's structured as
correctly-
member managed and then it's showing managing member and showing your name, is that what you're asking? Or are you
No, I'm asking
manager?
if it's structured as manager member, sorry, manager.
Manager
managed,
managed?
But then they can see who owns or all of the people in the LLC and it's one person.
So okay, so if it's structured as manager managed, they can't
They
see
can't see it.
who the
Okay.
members are.
Okay.
So that's what I'm saying, it's kind of a free way of shielding yourself from the public. Now, if information is not, like, it still has to be reported to the state. So like any seasoned attorney, at some point, when they come after you, they're gonna do like an asset search, there's, you know, different levels, right? But when I'm saying like free, most attorneys aren't gonna just take a case and say, oh, I'm gonna do this pro bono unless they know it's a smoking gun. So looking for as much free information as they can to say, are you a good candidate for us to go after? If not, they may still take the case, but they may say, okay, I need, you know, 50,000 as a retainer fee or whatever. Most people don't have a ton of money for frivolous lawsuits, so a lot of that gets alleviated at the beginning. We hope, right? So again, separation. Your current assets, like personal assets from your investments. It's important because they can be attacked and implicated both ways unless they're properly separated. So we talked about different levels of asset protection, dividing, you know, the liability based on values and the type of investment. So you may want, you know, 3 different LLCs for 3 different types of investing, or if you have high equity in one property, you're gonna wanna separate those out. And so one way for structuring sometimes that we recommend is to have a holding company and then have, you know, several LLCs for your different functions. Maybe one's an operating company, maybe it's a management company to collect rents. Maybe you don't want, you know, everything kind of under one umbrella. So it's smart to separate those liabilities and investments and the different functions out.
Would that be like a series LLC?
No,
Okay.
I never recommend a series LLC. So typically, the only state that they've ever truly been successful, if you research it, is Texas. In order to maintain a series LLC, I have maybe, so we've been in business 50 years, and I have one client that I've had for 36 years, like he's almost my age, but I'm saying he's been with our company that long, and he has a lot of companies. He's the only one that I've seen that has done it right. We usually won't touch them unless you've had an attorney navigate the process for you. So there's so much gray when it comes to series LLCs. And the problem is, so kind of like how the structure is, like pretend it's not labeled the way it is, right? The way a series LLC is, you kind of like have this parent company, and then you have all these subsidiaries, right? So typically, the whole purpose of separating the liabilities is this LLC has an operating agreement, its own like documentation, right? It'll have its own EIN. So it has its own like identity, right? You wouldn't want all of your children lumped together as, oh, that's the Young family and no one has names, right? It's kind of that same concept. So with a series LLC, it's the parent company with the name, and then it has one EIN, and usually people are thinking, okay, well, I only need to do the compliance at that level. That's where things get convoluted because each company is now connected to the parent. So if one gets sued, everything's gone. And so the law it's been really hard to interpret just because it was written kind of funny. And so Texas is the only place that where we've seen it be successful because there's attorneys that actually will help man it for you, but it's like 25 grand a year for them to do the proper compliance and documentation. And pretty much every series LLC that we've seen get attacked in court, the company's lost. So at some level, which is not good. That's like the whole purpose of having the companies is for protection.
So if you did your full compliance on each series, I guess, would you be in full compliance? Would that be the way?
So the series LLC, the problem with the series is, like the term series LLC, is that they're all connected, so there's no separation. So that's why I was saying in Texas, like there are some attorneys that specialize in series LLC, so if you're incorporated there, we've seen where they've structured it correctly, but it's so much compliance, so much reporting that we don't recommend it. We usually don't want to touch it unless we know someone's taking responsibility just for that because it's so much liability. To where if we do this huge giant structure, we're kind of separating out the Texas series LLCs and then we do everything else. So in something like this is just like a typical structure strategy to where now there's different types of trust. There's land trust, there's family living trust, there's asset protection trust, which would be like an irrevocable trust. We specialize in those. There's privacy trust. There's lots of different trusts. But one way to kind of like shield from the public is you could have like a privacy trust that you create. And the great thing about a privacy trust is you pay for it once and you can have it own 50 different companies or whatever you want can go under there. There's really no maintenance fees, whereas like land trusts and other things like that, you have to have trustees, there's maintenance costs and things like that. So sometimes you do like a privacy trust, for instance, this is just one way, right? So the privacy trust can own the holding company. The whole purpose of that is to shield your personal name from the public. So it'll show the trust as being the owner of the holding company and then the owner of the other LLCs that hold your investments, the holding company will own. So again, it's just, the more insulation, the more you can like shield yourself from the public knowing things, kind of the better.
So the ultimate would be to have an LLC in every state with a different EIN number.
Well, I would say every state, because now we're talking about maintenance costs of the state. There's lots of compliance, there's taxes.
Well,
We can do,
some charge taxes and some don't.
right, true. But, and I know as a tax professional, it's like, oh yeah, you have to file for taxes, but a good professional, make sure you don't pay taxes, which I don't know, because I always pay taxes. Ideally, if you're investing in different states, depending on what you're investing, if it's like buildings and land and something tangible, yes, in that state you'll want to. Now there are strategies we can do where we maybe do like an irrevocable trust and like an elaborate strategy to where there's only just a couple of LLCs, but they can get quite expensive and we'd have to do like a blueprint because it would have to be like customized to you specifically.
So if you had somebody like what we were just talking about,
Mhm.
and they needed a new tax person, because they just shot their last year's tax person, who would send them?
So, I mean, I'm not saying, I hope that's not the case, because you don't need a tax person if you're in prison. I'll just aside, I don't endorse anybody, but, we have relationships, we have affiliates with a lot of different people, not just in the community, but that we've vetted, that we've had like long-standing relationships, like 15 years plus, for lots of different things, credit building, how to navigate through lenders, for, tax professionals, different levels. So I have people who offer like turnkey tax advice, but also like the lending to where they can help you with the whole setup, to where we even have people that do tax strategies that aren't CPAs because they're like CFOs and they're like business people, right? So it just kind of depends on what you need, but we do, once you become a client, we have a referral program, and anyone we send you to will at least give you a free consultation. So you can kind of vet them and see, you know, if they're a good fit.
I have a question. What entity would the holding company be in?
What entity? So it depends. So again, it's not one size fits all. So it really depends on your situation. It depends on what you're investing, where you live, what the assets are, right? Because typically you would have like a consultation with somebody at our company. And we would advise you on what would be best for you, because it's really not a one size fits all approach. But to simplify things, let's say you have like this property is worth 500,000, it's paid off, so you'll have it a loan there. This one this LLC has note investing. It has 10 different notes across the US, right? So that will go there. And then this one here, you're doing fixes and flips, and you're doing a bunch of joint ventures. So that's separated there. I would probably recommend that holding company. And again, depends on if you have other things going on too, if you know, what your home is worth, lots of different things. If you have any other trusts or existing joint ventures that, like maybe you published a book or something, you have intellectual property, there's lots of things you want to consider. But this holding company in this scenario, where I would probably say it should be an LLC, and I would do it manager managed, and then this would be either an irrevocable, well, this wouldn't be an irrevocable trust. It could either be a family living trust, or it could be a privacy trust. If you wanted to do something more elaborate, we put an irrevocable trust over here and then another company, but that's a conversation for another day because it's really intense. Typically it'd be an LLC though.
So assuming that there were no notes involved, but
Mhm.
each of those is actually an investment property,
Mhm.
are you suggesting that this whole structure needs to be in a single state, or can the whole?
No, it does not have to be. So these all can be in different, the structure itself, they can all be different states. The trust is not going to be specific to a state either, if it's a privacy trust, for instance, or a family living trust. Usually the family living trust will be specific to the state that you're a resident of usually, and you'd want it to be up to date. But like your holding company could be like Nevada if you're a resident. Holding company typically could be Nevada or Wyoming is usually where we would go, depending on how elaborate. Most people that live in California do not want to pay the franchise tax board. It's $800 a year per company. They did waive it this year. I know they're talking about doing it next year. But who knows? As far as I know, they haven't made a decision yet. So I would not recommend all of these companies to be in California. However, if you're a resident there, there's other things we can talk about if you're investing in California. So no, the answer is no. They do not all have, the structure does not have to be stuck in one state. So again, we talked about weighing risk, how to separate out the liabilities. So you want to invest, make sure you have a strong foundation. So protecting yourself, of course. So here's some of the tax benefits of having a business, right? You know, all of these things are deductions and itemizations. So when you're doing your compliance, you'll have all that documentation in corporate record book, rather than going to your tax person and here's all my receipts, and you're trying to think of all these different things because you're like, oh my gosh, how did everything go up? Oh my, okay, so I'm in a higher tax bracket or whatever, and you're trying to offset all those costs. Your documentation, your resolutions also provides kind of an outline for your CPA or your accountants where you can be like, here you go. And a lot of these things are things that you can kind of offset. So like education and training, seminars, travel reimbursement, repairs and maintenance, marketing expenses, like all of those things, right? So sometimes people aren't thinking about like writing off bad debt, right? Or like, let's say, you had a bad investment, you know, you lost money. People aren't sometimes thinking about the losses too, so. So obviously big benefits, big responsibility. The higher your profitability goes up, the more money you make. The more responsibility, the more you're a target as well. So the biggest mistake most company owners make is they fail to do the planning. Either they don't know, right? Or they just, sometimes people know, like I have attorneys that come to us and have us maintain their books. So it's not that they're not educated, they don't know what to do. It's that there's a lot to do. And until you kind of get in the routine of doing your documentation, it's so easy to fall behind. So again, you know, the separation of the assets and liabilities to maintain the proper records, which is your corporate compliance. And I use that term kind of loosely because most people think, oh, well, I pay my fee to the Secretary of State and I have my articles of incorporation. That is just the state saying, yes, you can pay us money. So you can keep your company active and we won't audit you. The state like never audits you unless you don't pay, or if you're in California and you fail to pay the franchise tax board, then they'll come after you, like worse than the IRS. But your corporate records are all of your documents, and we'll go over that in a second. And then to meet the legal requirements, which again, the documents or whatever your state laws are, then also you have to adhere to the federal as well. So some common mistakes, commingling funds. So this is fun. Maybe you have like 4 different companies, you know, they can all do business with each other. So like, as I was saying earlier, one company can be like your management company where you're collecting rents. One company can be like, you know, purchasing the properties. Another company could do like the contracting, repairs and maintenance, and they can all do business with each other. But you have to be very careful because not just commingling funds, but not doing the proper documentation can get you into trouble, because then it's the perception of commingling funds or kind of having, you know, all the hands in one pot.
So as long as you have an organized, structured receipts or whatnot, a paper trail, you should be fine. Then it doesn't look like you're commingling funds.
Well, yes and no. For every action, there needs to be a resolution. That's a written legal document. You can do generals for like repetitive activities. So like if you know you're doing the same activity all the time, you don't have to do a resolution for each action. But that's like a legal document that you're making a decision, right? So maybe opening company credit cards, maybe you purchased an asset, you sold one, you opened a bank account. So there's general resolutions and then there's specific resolutions that like are either date or money related specific, that every time you do those activities, they need to be documented. So just the receipt is not good enough in the eyes of the law if you were to ever get sued. Like that's not proving legitimacy of the company. It's not proving that you're not commingling either. So keep personal and corporate funds separate. So a lot of times people will be traveling and they'll use their personal account to pay for an expense for their company or vice versa, right? They'll use their business account for personal stuff. And we're all human, we do it, it happens. But then again, you follow up with a resolution to document that action and then it explains it. Doesn't make it go away, but it clears it up that you're not commingling, you're not stealing from the company, you're not trying to hide money, right? So as long as you document that mistake, then you're okay. Also, failure to sign on behalf of the corporation. This is huge. Like I see people who spend thousands and thousands of dollars on really elaborate corporate structures. They're trying to do everything right, and they usually do. But one small little loophole where your whole thing can fail, there's 2, not being compliant. But let's say you are compliant, but you're signing on behalf of yourself, because sometimes when you're investing, they want that personal guarantee, right? So you have to sign your name. Maybe they don't want it under the LLC. Like let's say you're purchasing a property and you're getting a loan. Some lenders, seasoned lenders, will let you close under the name of the LLC. Some won't. They'll say, no, we don't need your personal guarantee. So then later you have to go quit claim the title under the name of the LLC. But if you sign just as yourself,
Your responsibility.
you're responsible. Like, let's say you're signing for yourself and you really want it under the name of the LLC and everything else is signed under the LLC. But then at the end, you're just signing your name. You need to put your name, comma, manager, or comma, president if it's a corporation, or whatever your title is, your signatory. If you don't do that, that could be the single determining factor where your structure will fail. So always use your title and make sure it's correct. I had somebody tell me, oh, I always sign my name and then member. I'm like, but your structure is manager managed. And she's like, I know, but I'm also the owner. And I said, yes, but we don't want to disclose that. So sign your name and then manager. If your structure is manager managed and you're also the manager. So for instance, if I had a corporation and I was a shareholder and my proper title was president, it would be Jennifer Young, comma, president. Other common mistakes, failure to identify as a corporation, not keeping the corporation in good standing with the state. So other things, to do nothing, to just like form your company and then not think you have to do any compliance at all. That's a big one. Failure to follow the rules will make you personally exposed. Tax penalties, liabilities, not keeping your dues with the state at the very minimum, you know, they can force it to be shut down. So the limited liability company, the whole purpose is to reduce your risk, separate your assets, and then provides tax deductions. If your records are not in order, you could be, if you're sued, then obviously you're stripped of liability protection and your tax benefits, and maybe even possibly your personal assets. Failure to keep the proper corporate records. If you're ever sued, you have a 50 to 94% chance of losing your personal assets. That's kind of a huge, right? 50 to 94. But the reason is because it depends on what your personal assets are and the value. So each state, like let's say your home is homesteaded. If you have your home homesteaded, each state allows you up to a certain value. I don't remember what Nevada is anymore. It seems like it recently changed.
Yeah, it's going up.
What was homesteading your property in Nevada? It's like for a certain protected value, but let's say it's like 400,000. Is it 900,000? Okay. Each state is different. I have people that think that they're homesteaded in California, that they're like safe, and I'm like, well, if your home's worth $2 million, it's only homesteaded at 400,000. I'd be a little worried, you know. 550. 550. Okay. Okay. Well, that's in this market. That's not great, but it's something, right? And there's laws that protect you for your personal residence, right? So. Usually your personal residence is protected in the event something happens unless you do something super illegal or catastrophic. Usually though, your other investments are the first things they'll go after. That's why you really want that separation. But they could force you, like if you have a lot of equity in your home, you do something super, super not smart, the judge could force you to sell your home. Their percentage is small, but it could happen. Now, anything additionally is up for grabs if it's not properly protected. And again, family living trust, people keep telling me, oh, I have everything under my trust. I'm like, oh, good. What kind of trust is it? It's a family living trust. That is you as yourself until you die, and then it becomes irrevocable. And then, you know, it goes to your beneficiaries just to avoid probate. There's no protection other than maybe people not knowing that you own the trust. But most people say young, young family living trust. So you just told on yourself right there. Which, by the way, if you do have a trust that you're working on, don't. Most attorneys don't know, but if you go to the right attorney, then you don't have to use your name, and I wouldn't. So that way, at least you have some anonymity. What you do to protect your benefits is important. So we were talking about the compliance. The minutes is just one component of that. So there's a lot of documentation, but just like general rule of thumb, there's minutes and there's resolutions. The minutes are a summary of the meeting showing significant issues discussed. They identify decisions at a specific time and location. It's an essential tool in establishing the legal separation between the owner and the company because it's laid out in writing. Courts may request these minutes as evidence, so it's super important. All 50 states require minutes for both LLCs and corporations. And then it's also the memory of the company. So if you've been in business for 50 years and you want to sell it, saying, oh, this is an H company and I've been doing all of this, it's valued at this, you have no documentation, they're like, okay, so we take your word for it. So this is huge. Also, another thing with the minutes, so typically when your company is first formed, it's initial meeting minutes that you have to do annually for each year. Special meeting minutes for like major infrastructure changes or if you're issuing stock or changing membership. Resolutions. So the resolution is a written document that describes an action taken by the board of directors or the managers, right? It's a permission slip basically for the company to do certain actions. So you can do general resolutions for things that are repetitive. You could put ceiling amounts in there and such, and then again, specific resolutions for anything like date or money related specific. Super important. This creates the timeline of the event. So when you ever hand over to the IRS or a court proving legitimacy, it shows an outline of the different transactions. That's where you're getting your charging order protection. So these are your compliance documentation, doing the different resolutions. So all of these things require resolutions. Don't get overwhelmed. You're fine. It really can go on and on. But so don't let it scare you. It's gonna go. So the different actions that you're taking need to be documented. I mean, it is just super important. So registered or resident agent services, that's who's appointed to accept legal process paperwork on your company's behalf. Some people appoint themselves, but then they're never at the address they provide to the state. Bad idea. You should always have a third party unless you're in like a staffed office or you're always at that address. Just kind of want to point that out. But you also need a resolution documenting who that person is. So if you already have an LLC, are you compliant? So if you're interested in seeking services, that's something we do. We do very elaborate strategies and structuring and things like that. But we also do the corporate compliance. So when we form a company, we bundle it with our services and we handhold you for the first year. Because we want to make sure you're compliant, you're getting the asset protection, and that we're educating you on what it means to be compliant. It's super important. As I said, we've been in business for 50 years. I guess when they first started forming companies, so many people were running into tax issues or not being compliant with the state or getting sued left and right. And so we formulated a program that's called the Corporate Veil Protection Service. And what it is we do all of your compliance documentation. So if we form the company for you, we're doing all the bulk of the documentation, and then we're kind of teaching you throughout the year, the services for a year. We teach you on what it means to be compliant and how to take on these responsibilities yourself if you choose to. So we bundle those services to make it affordable. Our rates really don't change. The only thing that changes is when we bundle the services, the package comes with the LLC or the corporation or the nonprofit. So the filing fees within the state and whatever else is required, like Nevada requires a business license, so that would be included. It'll come with that corporate veil protection service package where we do unlimited documentation for compliance for the first year. If you have an LLC, it'll come with your operating agreement, your membership certificates, a corporate record book binder to keep all your documentation, and we do all the minutes and resolutions. That is backed with $125,000 guarantee to where if you're ever audited or sued, we prove separation. We prove that you've been compliant. So we don't want to pay out your judgment against you, but we will pay out X amount if they say that you have not been compliant. So we stand by that guarantee. The only other difference would be like the compliance is a little different if you have a nonprofit. It's, the bylaws, instead of having shareholders, we do that for you. And then they have meeting minutes monthly rather than just annually. And then if it's a corporation, the documents are a little different because obviously instead of an operating agreement, it would be bylaws. and instead of membership certificates, it would be stock certificates. So that program is called the Corporate Bill Protection Service. It also comes with the registered agent service, where we accept legal process paperwork on your company's behalf. So like every state nationwide has been mandated to have a person that is appointed to represent your company to assume that liability. So like, let's say someone is suing you and you have, you know, your mom as your registered agent, because she's retired and you figure she's always gonna be home, but she's out gardening all day. When they come to serve her at the address that's provided to the state, if they're knocking at 4:58 on a Friday and she's not there to serve, then they just go down to the courthouse and get a default judgment. It's like an act of God to get that overturned, so that's why it's been mandated in all 50 states that everybody has an appointed person that's assuming that liability. So if you're in a fully staffed office, you can appoint yourself, that's safe, if you know you're always gonna be there Monday through Friday 8 to 5. But if you're out in the field, right, and you're never at that address, then I would recommend having a third party. That is something we do, and so when we form a company for you, all those services are bundled for the first year. And then if you have an existing company and you're out of compliance, we offer these services as well. And then there's different tiers based on how old your company is. So just so you know, if you're interested. And then we do seminars twice a year about, we focus on growing your wealth. And we talk about asset protection. We have a lot of affiliates there and things like that and resources if you guys are interested. I will leave a stack of my cards over here. So if anybody's interested in learning more or needing referrals to anyone, or if you'd like a complimentary consultation, let me know. The blueprint is what I was telling you guys about, where that's kind of the starting point. If you, two ways, if you have a lot, you've done a lot, and you're like, now I need damage control to figure out where this all needs to be placed properly. Good for that. Or if you're in the beginning and you're like, I need to know how to properly do this to take the right steps. It's a customized strategy that we build for you, and we'll make recommendations in phases. So let me know if you're interested in that.
You do California homes?
Do we do?
LLCs for California as well?
Yeah, we do. Oh, I'm sorry. We do LLCs in every state nationwide. Yeah, and so the package that I was telling you about is called the turnkey package, where everything is all inclusive. We literally don't sell the other packages unless it's like a seasoned attorney or a CPA that's done many companies and they know how to be compliant. Just because we want to make sure that you're successful.